Can't sell, can't refinance, can't insure. What's happening to land titles in BC? In August, a BC Supreme Court judge transferred roughly $500 million of government land in Richmond to the Cowichan First Nation. Then 125 to 150 private homeowners in Richmond received a letter stating that their titles could be compromised or potentially invalidated. So, what actually happened? In a landmark decision, the court recognized Aboriginal title over this government Richmond land, but it included areas with private property. And that's what's raised province wide alarm because 95% of BC is unceded and therefore open to similar claims. But what did the court actually say? The court declared that the land owned by the Crown, mostly strategic lands, was defective and invalid, but it made an important distinction between government land and privately owned land. For the land held by Canada or the city of Richmond, the titles were voided because they were granted without constitutional authority, which then infringed on the Cowichan title. But for private owners, the court did not cancel their titles. These owners weren't part of the lawsuit, and the Cowichan asked them not to validate them. Still, the court ruled that the original Crown grants were an unjustified infringement, and therefore BC must negotiate in good faith with the Cowichan to reconcile their interest in this land. The province and the Cowichan have about 18 months to figure it out. But the real issue is that the ruling created something that we've never seen before. Two competing land titles on the same land. Fee simple ownership and Aboriginal title. And there's no framework defining how these two can coexist, or even if they can. Aboriginal title is collective, but it's the right to live on, use, manage, and benefit from the land. Fee simple title is the same. It's individual ownership, the most complete form of ownership with the same rights and exclusive use. So the issue is that both Aboriginal title and fee simple grant the same exclusive use. And so how do you give two parties exclusive use over the same piece of land? In the case of how the province and the Cowichan can reconcile these issues, perhaps there might be buyouts for the private owners, co-management agreements or oversight by the nation, or compensation and revenue sharing through the Crown with respect to those lands. The Cowichan lawyer said that the buyer and seller will get what they're bargaining for, but with some accommodation from the Crown to the Cowichan Nation. So perhaps it would be like a strata model where you still own your home, but you operate under another layer of governance. But the fallout so far is clear. And without this framework, the ripple effects are here and hitting home. So 18 months is a long time. You've got homeowners that can't refinance or get you mortgages because banks aren't sure that their collateral is secure. You have insurers who don't know who they're insuring or how much to value the property for, and you need insurance to get a mortgage. And buyers are probably backing off because they don't know who has title to the land. And today, a major bank just pulled funding for a $100 million project. So that company's just going to cancel the entire project due to this land title uncertainty, which won't be clarified for 3 to 10 years. Who knows how long an appeal can last? So why this all matters is because this case is precedent setting. It confirms that Aboriginal title can be declared over private land, and that opens the door to similar cases. Until a framework is created and is actually proven to work in reality, the real estate market and the public confidence in it is going to remain in limbo. And this isn't just a court case. It's a reminder for all of us to get and stay informed about what our governments have been up to and about how our laws are changing, and that might affect us all across BC.